Good morning, ladies and gentlemen, and welcome to another episode of PLA with myself, Nick, and Bruno. We've got 3 questions today, and we'll be separating them where we'll be doing 2 separate ones with Nick, and then we'll jump into the last one with Bruno. Nick, the first question is from Otto, who's one of our regular viewers of our channel. And then Otto says, please advise on the legal standing on an entry inspection on a commercial property if the lease agreement is either specifically excludes it or is silent on it. Nick?
So it's a really interesting clause. I've never seen a clause in a lease agreement, and Bruno and I were discussing beforehand on a lease agreement that excludes inspection. That's very arbitrary. I don't know if perhaps it's just a wording problem. There are certainly lease agreements that are silent on entry inspections, but for something to exclude an entry inspection, that's an interesting clause. The difficulty I am having here is this is a commercial property. Okay, so if this lease agreement fell within the realm of the Rental Housing Act, this wouldn't be an issue because then there are requirements that are deemed to be part of the lease agreement, which deals with entry inspections. And if the lease agreement went against that, those clauses would be unenforceable. You would have to apply what's part of the Rental Housing Act. But this is a commercial lease agreement, and so that act is not going to apply. And the ultimate authority on a commercial lease agreement is the document itself. Okay, there is nothing else in law that dictates how the agreement should run, except for what is contained within the lease agreement. So if there is a clause which specifically excludes an entry inspection, there's really no right to insist that one must occur in the circumstances. Notwithstanding, you wouldn't be able to apply to a court to get specific performance and enforce it. But notwithstanding, it is in the best interests of both the landlord and the tenant to do something like an entry inspection. Practically, this safeguards everyone in a particular, in the transaction, and it's just safety. Especially, you've got to remember when it comes to lease agreements, these are long-term contracts. Even if they're not, in law long-term, 6 months, a year, 2 years, these are long periods of time for you to remember what exactly the state of a premises was at the time that your tenant took occupation. And so a clause like this, really, I don't see the benefit for either party to go into something blind like this. I think really practical minds should come together. Yes, there's no ability to enforce it in law, but I think practically both parties really ought to do the entry inspection. There's very little downside to doing it. It takes some time, a little bit of time out of your day, but it's going to protect you a lot down the road. So I think while from the information I have here, Johan, I can't say that there's a way to enforce it, but I would say practical minds should come together on this one. Talk about an entry inspection, regardless of what the lease agreement says, and see whether you can't do something in the circumstances. It's really the best way to go in this particular circumstance.
Absolutely. So thank you there very much, Nick.